Yes. Yes, sir. It's Kenya.
Pena, excuse me, Miss Wallace, excuse me, thank you. You've been charged in case 23 CR 007130F with tampering with evidence. Is there a history? Do we have anyone on from pretrial?
Your Honor, this is actually conflict case, and I don't see conflict attorney, Your Honor.
Okay, thank you, Ms. Kim.
We can go to position 17. With Chacon. Oh, here's Miss McLeod.
Okay.
Hold on, go ahead. Come on, Wallace.
Good afternoon, Ms. McLeod.
Good afternoon, Your Honor.
We were just on position number 20, Ms. Kenya Wallace.
Yes, Your Honor, that is my client.
Yes, and are you ready to proceed with Ms. Wallace?
I am, Your Honor.
Okay. Who do we have on from pretrial? Is there anyone on from pretrial? Doesn't appear so.
In a minute, Judge Morrow.
Okay, thank you. Good afternoon, Ms. Strong. Mr. Pierre Thomas, do you have the history?
He has. Appears to be his first arrest, Your Honor. Appears to be he has one cycle.
Okay, you can proceed.
I thought it was a she.
It is. It's
she. I'm sorry. My apologies. Okay. Your Honor, brief facts of the case is that law enforcement was dispatched to 2048 Stanton Road, East Point, which appears to be the location of a chevron in reference to a person shot. The officer arrived on the scene and immediately observed a man identified as Nyante Trasher lying on the ground on his back. Mr. Trasher had lacerations to the left side of his forehead and was bleeding profusely from somewhere in the midsection of his body. The officer on the scene blocked off the scene and began an on-scene investigation. The first person the officer spoke with was the defendant, who stated that she was walking northbound in front of the incident location with Mr. Thrasher when an unknown man walked up to both of them and stated give it, basically appears to attempt to have robbed them. The defendant stated that the man pointed the black firearm at both of them. Mr. Wallace stated that the next thing she remembered is this male beginning to shoot towards her and Miss Thrasher. Miss Wallace stated that this is how Miss Thrasher obtained her injuries. The defendant, one moment, Your Honor. At some point, the officer spoke with a Miss Darrera Tall, who stated that she was at the gas station getting gas with her friend when she heard the arguing, and immediately after she heard the gunshots, one of the bullets went through her windshield. While she was in her vehicle, the officer observed one bullet hole in the upper left side of Miss Tall's windshield. Miss Tall stated that she was not able to see who shot her. Miss Tall stated that she had pain in her left eye. Medical treatment was provided on the scene. The officer then spoke with Miss Amber Ponder, one of Tall's friends who was with her. Ponder stated that she heard a female arguing with someone, and immediately after her gunshot, she observed a black female shooting and running in front of the incident location, but could not recall what this female was wearing. Miss Ponder had minor cuts on her legs from when she dropped to the ground and she heard the gunshots. The officer observed the two bullet holes that struck the chevron. While on the scene of East Point, the detective conducted their investigation into the incident and discovered that the defendant was a participant in the shooting that took place. The video surveillance revealed that to them that after Mr. Thrasher was shot multiple times, the defendant hid her gun and the victim's gun under some rocks behind 2057 Stanton Road, northeast. I'm sorry, in East Point. The detectives were able to locate the two firearms, which the defendant was seen in the video shooting. She was then placed under arrest. The recommendation from the state is a $3,000 surety bond, no alcohol, drugs, or weapons, and OP-21. And for her to surrender all firearms to the Fulton County Sheriff's Office.
And all she was charged with on this whole incident was tampering with evidence?
It does appear so, Your Honor.
Okay. Yes, Ms. McLeod.
My client is 19 years old, Your Honor. She is currently unemployed, although she's a high school graduate. She tells me that she has been looking for employment. She denies the allegations made in the warrant, Your Honor, and this is her first arrest. I would ask the court to give her a signature bond so she can get out of jail. She's 19 years old, so she is an adult. If the court believes that she needs to have a co-signer, she does tell me that she lives with her stepmother, and I have a good number for her stepmother, Your Honor, although I was unable to contact her, but I can try to continue to reach out to her stepmother if the court deems that that is required.
Given that she does not have a history, Ms. McLeod, it'll be a $3,000 signature bond through the jail. Stay away from the Chevron on Stanton Road. No drugs, alcohol, or weapons while out on bond, meaning that if she has any weapons, that she's going to have to surrender those.
Thank you, Your Honor.
Okay. Good luck to you, ma'am.
Your Honor, good afternoon.
Good afternoon, Ms. Falk.
We have a bit of an unusual request, and let me just ask my victim advocate if she can type to me in the chat if the victim on position 12 is present and here in court. And Miss Cheney, if you could just send me a heads up in the chat. Okay, so she is not here. So position number 12, Chris Johnson, we were alerted that the defendant who was arrested is actually not the same person that committed the offense. Apparently there were two Chris Johnsons. This Chris Johnson happened to be at municipal court in Roswell and was picked up on a warrant for a different Chris Johnson. So I'm not sure now. The issue is obviously not Mr. Johnson's. We're going to have to determine how to revive that warrant because the warrant is still technically needs to be reactivated because they picked up the wrong person. However, we are going to go ahead and do a dismissal of this charge against this Mr. Johnson since it is not the same person who committed the offense that's in this case.
Okay, and is this Mr. Johnson that's before me here, or is this someone else?
Looks like he's nodding his head.
It's gonna be Chris Johnson.
Okay.
Okay, I just wanted to make sure that this was, and who's representing Mr. Chris Johnson?
I do, Your Honor.
Okay, so this Mr. Johnson is a junior. Do we know, Ms. Falk, if it was somebody that's related or not related to?
Apparently this person is completely unrelated to the Chris Johnson who committed the offense.
Okay.
He just happened to be in the wrong place at the wrong time, and there was an active warrant, and he was picked up in lieu of the correct Chris Johnson.
Okay. So, Mr. Johnson, your case is going to be null prossed. I'll get that null prossed, and you will be released. And Ms. Kim, anything that you need to put on the record regarding this matter?
No, Your Honor.
Okay. And Ms. Falk, I guess you can move forward with the warrant that you need to sign for the correct Chris Johnson as time moves on.
Yes, Your Honor.
Okay.
Thank you, Your Honor.
All right. Yeah, good luck to you, Mr. Johnson.
Position 17, Pecan.
Your Honor, I only had that one case on the calendar. May I be excused?
Yes. Have a good weekend, Ms. McLeod. Thank
Thank
you.
you, Your Honor. The same to you.
Yes, good afternoon, Mr. Pecan. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes. Yes, Your Honor.
Thank you. Thank you. You've been charged in case 23 CR 007127G with battery family violence. Afternoon, Mr. Howard. Is there a history?
Hey, second arrest, 2022 suspended license, level 1.
Your Honor, brief facts of the case is that the law enforcement responded to a domestic violence call at 2086 Branches Drive in Roswell, Georgia. The officer made contact with the victim in this case being Rocio, Rocio, Carrillo, Carrillo, Deloya, Deloya, who told the officers that her daughter's boyfriend, the defendant, slammed her on the ground after he tried to take her daughter. Looks like victim, I'll say victim's initials is DF, phone and leave the residence. Diana began to wrestle with the defendant for the phone, and the victim began to fear for her daughter's safety due to the defendant's increased aggression. So she intervened and tried to break up the altercation. The defendant began to attack the victim, picking her up into the air and slamming her to the ground, causing bruising, redness to the right side of her face and multiple scratches on her hands, arms, and legs. The officer observed all of these injuries, and they were captured on his body-worn camera. On the officer's body-worn camera, the defendant fled on foot after the victim told him that she was calling the police. Both the victim and the other witness and the defendant all live at the incident location together, Your Honor. Your Honor, the recommendation from the state is a $2,000 surety bond, a stay away from that incident location. Again, that's 2080 Six Branches Drive in Roswell, Georgia. A no further contact with the victim, the completion of a family violence intervention program, and no drugs, alcohol, or weapons. And if at this time we can sound for Ms. Deloya in accordance with Marcy's law, that'd be greatly appreciated, Your Honor.
Okay, before I do that, Mr. P, I'm a bit just confused on, Ms. Deloya is
The mother,
the daughter's,
the daughter is the one whose initials are D and F. And I just want to ensure that she's not a juvenile. If she can give me 2 seconds, I can then tell you the full name of that person. If that's the case, we'd like a no further contact with that person as well.
so, this is Ms. Deloya that's on the line?
Yes.
Okay,
And
let me
she can
get
tell
her
us if they're juvenile or not.
Well, and I'm a bit confused as to the facts. So, Ms. Deloya, if you would like to address the court, now is your opportunity to do so. If you would like to, I'll need for you to raise your right hand. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, thank you. You can put your hand down, ma'am. Tell me, who is Mr. Pecan to you?
He is my daughter's boyfriend. He's also, so I consider him my son-in-law.
So your daughter's boyfriend. What's your daughter? Is your daughter a juvenile?
No, she's 23.
Okay, what's her name?
Her name is Diana Flores.
And so you and your daughter, Ms. Flores, and Mr. Pecan all live at the Six Branches Drive address?
Yes, Your Honor.
Okay, all right. So now that I have that, now that I understand that, go on. What would you like to tell me?
I would like to say that I think Gabriel made a mistake. I think he has spoken to us. We are willing to work with him. He has promised to go to our church and seek help. He's promised to also seek therapy for if he does have an aggression problem or a violence problem. I think, it's quite sad. He moved down here. He doesn't have any family down here. He moved down here in hopes to have a relationship with my daughter. They're trying to get their feet on the ground, so they had to move into our house. There was alcohol involved. I think he's only 21, my daughter's 23, and they're trying their best. I feel responsible in a sense because I'm the older adult here. Things should have went differently. I don't, I'm here to support them both, and my husband and our family know, he goes to work every day. He's a good guy. He's not a thug, and this incident was very unfortunate, but you know, it is sometimes we have to face the consequences of our actions. I don't have anything against what's going on. I think it's important for him to see that, hey, your response is your responsibility. So that's why we're here today. But, we're not dealing with somebody who is on drugs. We're not dealing with somebody who has any other issues other than him and my daughter. As a mother, it's kind of hard. And I've said that to him. It's kind of hard, you guys staying at the house. And if you guys want to fight over a stupid phone, it's hard to, not want to get involved if you guys are like going back and forth, shoveling. Like, I'm going to need you guys to work on that and figure out you guys need your own space and seek some counseling. But I do think it's important to note that we're not dealing with somebody who is a troublemaker or a thug. I keep trying to take myself back to that day. I also take my responsibility for my part. I do think that it's not a lost cause. I think that we can work together and that we can get to a better place. And I think that, he's not a bad person. My children love him. My younger kids love him. My husband loves him. I love him. I think it was just one of those things that just got out of control and it affected our family. Kind of felt like the devil came in here, chewed us up, and spit us back out. But we are doing what we're going to do. We're going to stand together. We're going to fix this. And I apologize that we're in front of your court today, taking your time, but we're here to face the consequences of our actions and we're taking full responsibility.
And so, Mr. Lawyer, my question to you is, do you want Mr. Pecan back in your household or not?
Yes, he's welcome back into our household. He doesn't have any family here. He doesn't have anybody here besides my daughter. They're staying here with us because they didn't have an apartment or a place to stay. So yes, he is welcome back in our home.
Has this ever happened before to your knowledge?
No, Your Honor, it has
And you're
not.
And are you afraid of him?
No, I'm not.
Okay.
And he knows that now. And I think with this, he knows if this were to happen again, he knows I will press charges and I will call 911. I understand I have all the support in the world, and that's kind of the message I wanted to put out there, and that's what we're doing today.
Okay. Thank you for being here, ma'am.
Thank you.
Yes, Ms. Kim.
Your Honor, so okay, my client is 21 years old. We would like to make sure that he gets a signature on bond through jail. He is very responsible. He works hard at a janitorial company as an operating manager. It's called the Georgia Facility Service. And Your Honor, he graduated from high school and he also tried to become a firefighter, but it didn't work out. However, he's very responsible for what he does. We would like to request for no further violent contact since this happened on November 11. There has been ample cooling off period, so they are okay with each other, one another, so they can come back and stay together. No further violent contact, please. Thanks.
Okay, it will be a $2,000 signature bond through pretrial level 1 day anger awareness. No further violent contact with Ms. DeLoya or Ms. Flores or Ms. DeLoya's family. No drugs, alcohol, or weapons while out on bond. All right. Good luck to you, Mr. Pecan. You also, Ms. DeLoya.
Thank you, Your Honor.
You're
Good
welcome.
afternoon, Your Honor. This is ACDC. Before you is Ms. McElroy. I'm sorry, I don't have a position number for her.
Good afternoon. Let's see, Ms. McElroy is position number 14. Good afternoon, Ms. McElroy. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 007121A with simple battery. Is there a history, Mr. Howard?
Second arrest, 2009 terrorist threats, ag assault, dead doctor. This was a jail recommendation.
Mr. Pierre Thomas?
Yeah, brief facts. I understand it's a jail recommendation. Brief facts of the case is that the incident took place at 234 Memorial Drive, Atlanta. Upon arrival, the officer spoke with the victim. The victim in this case is Terry Refuge, Refuge spelled R-E-F-U-G-E, who stated that he had a verbal disagreement with the defendant. The victim left the hallway area to report the incident to security in the front lobby, and the defendant followed him there. The defendant got upset before punching him in the face multiple times. The victim did not strike the defendant back and placed his hands. The victim placed his hands in front of his face before she hit him with a bottle. The defendant and the victim and the defendant are neighbors. The security manager there stated that the victim entered the lobby area to tell them something when she witnessed the defendant punch him in the face multiple times, corroborating the victim's story. She stated that the victim did not strike the defendant back, but only placed, as again corroborating the story, only placed his hands over his head, protecting his face. There is security footage of the incident. Despite it all, Your Honor, the recommendation from the state is a signature bond through the pretrial services, a stay away from that location, which is 234 Memorial Drive, Southwest Atlanta, Georgia. No further contact with the victim in this case, Terry Refuge. The completion of 8 weeks of anger management, no alcohol, drugs, or weapons. If at this time we could sound for Mr. Refuge, in accordance with Marcy's law, that'd be greatly appreciated.
234 Memorial Drive. What is that?
I believe that's the address for the victim, but let me double check, Your Honor.
Is it an apartment complex? Is it? You said they were neighbors, so I want to make sure that I'm not that if it is an apartment complex that.
I'm checking right now, Your Honor.
Okay. Good afternoon, Mr. Ty.
Good afternoon, Your Honor. My client is a 51-year-old resident of, and this location is actually called the Welcome House. It's housing for, I think, people who have been homeless or cannot afford housing. So it's an apartment complex. So she does live there at 234 Memorial Drive in a separate unit, of course. I wasn't able to contact management at the Welcome House. My client is working with several social workers who I guess have placed her in that housing complex. She is not employed. She doesn't make any money, cannot afford any bond. She's recently lost her son who was murdered, and so is struggling with depression and coming to terms with the murder of her child recently. She doesn't have a phone. She doesn't have anything, but she does have this home. And so it's important for her to be able to return there. And she can stay away from Terry Refuge, the complaining witness. She denies the allegations. So we're asking for a signature bond, which she's recommended for, and no further violent contact with Terry Refuge. I was able to speak with the manager, Suzette Weaver, and she said that I'd have to talk to somebody else to just confirm that she would be able to return to the housing. She is able to. They haven't restricted her. I just wanted to have somebody on to say that she can stay away from Terry Refuge. They are in separate units. I don't think it will be a problem.
And that location is the Welcome House residential, and I do believe that no contact is appropriate, not a no further violent contact. And I understand I guess the sensitive nature of them being neighbors in the stay away. But if we could put some sort of restrictions on it, that'd be greatly appreciated.
If Mr. Terry Refuge is on the line and wishes to address the court, now is your opportunity to do so. Okay, it'll be a $2,000 signature bond through the jail. No further contact with Mr. Refuge. Stay away from whatever apartment unit he is. I'm not going to restrict her from going back to the Welcome House, but she is restricted to have no contact with him and not to go back or go to his unit. No drugs, alcohol, or weapons while out on bond. Ms. McElroy, I'm sorry for your loss, ma'am. Good luck to you.
Thank you.
Thank you, Your Honor.
You're welcome.
Next, we have Ms. Munns, M-U-N-N-S.
Ms. Munns is position number 16. Good afternoon, Ms. Munns. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Munns, you've been charged in case 23 CR 007122D with willful obstruction of a law enforcement officers. Is there a history, Mr. Howard?
10th arrest. Last arrest was in February. Forgery, first degree. Got a theft of services from this year. Identity theft fraud as well. 2014 probation violation, 2012 burglary conviction. And I think I saw open CP case too. That's it. This was level 3.
A brief facts of the case is that the law enforcement arrived at 2751 Deerwood Drive, Southwest Atlanta, to execute a warrant in an FTA case. Upon arrival, the deputy saw a wanted person looking out of the window. After knocking on the door, the defendant answered the door, and deputy advised the defendant that they had a warrant. The defendant blocked the doorway and refused to let the deputies enter. The deputies told the defendant that she would be arrested if she did not move, but she still refused and was arrested, Your Honor. The recommendation from the state at this time is a signature bond through the pretrial services, no alcohol, drugs, or weapons.
So they did they execute a warrant? What was there? You said that they saw.
Yeah, it looks like the warrant was for 23,000,834 FTA. I can ensure that was her if it pleases the court. Doesn't appear that FTA number is attached to her case, but let me double check, Your Honor.
I just need to know that regardless of what we do, was she the person that they were looking for? And if not, does she doesn't have an FTA out?
Okay.
No, it's not for
Okay.
her.
Oh, okay. If okay with you, Mr. Ty, it's going to be a $2,000 signature bond through the jail and no drugs, alcohol, or weapons while out on bond. Does that suit you?
Yes, that's fine, Your Honor.
Okay. Good luck to you, Ms. Munns.
Thank you. Thank you, Your Honor. Have a good evening.
Okay, you do the same. Be safe.
Position 19, Thompson.
Good afternoon, Mr. Thompson. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Did you hear me, Mr. Thompson? I'm sorry, I can't hear you.
Oh, yes.
Okay, thank you. You've been charged in case 23CR007129Y with battery. Is there a history, Mr. Howard?
3rd arrest. Last arrest was in June. Simple battery out of Cobb. And the open criminal damage to property 2nd degree. So we got 2 open cases out of Cobb. This was level 2.
Yes, Mr. Pierre Thomas.
Your Honor, brief facts of the case is that law enforcement was dispatched to 6615 Roswell Road, Sandy Springs, Georgia 30350, which appears to be the Jets Pizza, in response to an assault. The incident, a verbal altercation became physical that occurred between 2 employees at the Jets Pizza, the defendant and the victim. The victim in this case looks like Collins. Last name is ENEMOH. Upon the officer's arrival, they met with the victim, who is the assistant manager at the Jets Pizza, and the defendant, who is a delivery driver. The victim explained that the defendant attacked him after an argument over the defendant's late delivery, which turned physical. The defendant became combative, pushed him, and began striking him. While attempting to get away from the defendant continued to approach the victim. Another employee on the scene said that he saw the defendant continue to approach the victim and corroborated the story. The defendant approached the victim to fight him and advised that he even took his shirt off to continue. The witness advised the defendant even took his shirt off to continue the fight. He also stated that he told the defendant to stop, but was ignored. Upon speaking with the defendant, the officer observed, upon speaking with the victim, the officer observed visible scratches, whelps, and visible blood on the left side of the victim's neck and face area. There were also visible scratches and whelps on the right side of the victim's face. Victim confirmed that the injuries observed were from the defendant striking him. The defendant did not have any visible marks or bruises or scratches on his body. The recommendation from the state appears to be a $5,000 surety bond, a stay away from the Jets Pizza located at that 6615 Roswell Road, Sandy Springs location, and no further contact with Mr. Enomoh, Enemoh. The completion of 8 weeks of anger management and no alcohol, drugs, or weapons. And if at this time we can sound for the victim, Mr. Enomoh, in accordance with Marcy's law, that'd be greatly appreciated, Your Honor.
If Mr. Enomoh is on the line and wishes to address the court, now is your opportunity to do so. Doesn't appear so. Ms. Kim?
Yes, Your Honor, my client is 28 years old. He was born in Ohio, but he moved to Georgia when he was 7 years old. So he has been here in Georgia for 21 years. He has been here long enough to have a strong ties to the community. He graduated from college. He went to Louisiana State University, majoring in sports administration. And he also has 2 jobs. He's working very hard. And Your Honor, the incident at Cobb County, he's presumed to be innocent. It is just mere open case. There was no conviction whatsoever. So we would like to request for a signature on bond through pretrial, so that way he can be monitored. I don't think he will have any trouble or problems, Your Honor. He has his mother who will be supporting him and making sure that he is coming to the court. He will be responsible. We would like to request for signature bond through pretrial. And we are okay with staying away from Jet's Pizza and no further contact with Mr. Collins. He was fired. So I don't think he needs to go back there. Thanks.
And Your Honor, if I could make an update to the state's recommendation, the state would recommend a $3,000 surety bond in this case.
Okay.
It's currently set at a $5,000 surety bond.
It will be a $3,000 signature bond through pretrial level 1-day anger awareness, no further contact with the alleged victim, stay away from the Jets Pizza on Roswell Road, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Thompson. You're welcome, Ms. Kim.
Position 11, Jackson. It's locked. Right here is fine. You're good. You're good. You're fine.
Okay. Good afternoon, Mr. Jackson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Jackson, you've been charged in case 23 CR 0071226E with public drunk and 2 counts of willful obstruction of law enforcement officers. Is there a history, Mr. Howard?
23 total. I got open cases out of Fulton, possession of a firearm by convicted felon. You want the case numbers?
No, that's fine.
Open ag assault, 2023 failure to appear. 2020, possession of a firearm by a convicted felon, possession of a firearm during the commission, possession of a Schedule 1 or 2, and those were not prosecuted. 2019 DUI, 2017 obstruction, 2016 battery, 2013 probation, and the FTA from 2010, level 3.
Afternoon, Ms. Dunlap.
Good afternoon, Your Honor. So this incident stems from the 16th of November.
Officers were seen the defendant at 680 Lee Street Southwest, drinking a Bud Ice alcoholic beverage. He appeared to be intoxicated. He was slurring his speech. He had a staggered walk, and he had a strong odor of alcohol, according to the officers. He verbally and physically refused to abide by any of the officers' commands, and he tried to flee the scene when they attempted to arrest him. It looks like it's currently set at a $3,000 surety bond. On the public drunk, we want to reduce this to a signature bond through pretrial, a stay away from 680 Lee Street Southwest, drug and alcohol course, and no weapons, drugs, or alcohol while bond.
Mr. Ty, does he have a place to reside?
Yes, he does. He lives at 4017 Gray Green Drive in Decatur.
Okay. You can proceed.
Your Honor, my client is a 42-year-old father. He has a 15-year-old child. He has recently been injured at work, so he does not have that job. He doesn't make any money, can't afford any bond. He's been shot twice in the leg and in the shoulder. States that since being in custody, he's been dragged around so much. That's why he's in the wheelchair now. He's in a lot of pain, and we're fine with the state's recommendation for the signature bond and the stay away from 680 Lee Street. He does deny the allegations.
Okay. For each count, it's going to be $1,000 signature bond through the jail. So it makes for a total of a $3,000 signature bond through the jail. Stay away from 680 Lee Street, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Jackson.
Thanks, sir.
Welcome.
Position 13 Jones. Somebody got a
And this,
Judge, I'm sorry, did you hear me? This is position 13 Jones.
I did, Principal. I just wanted to make sure that you were done with
Yes,
gentleman here. Okay.
thank you.
You're welcome. Good afternoon, Mr. Jones. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor. Good afternoon.
Thank you. Good afternoon, sir. You've been charged in case 23 CR 0071116E with terroristic threats and acts. Is there a history, Mr. Howard?
7 total. Last was 2022, afraid. That appears to be open in state court. Before that was a 05 armed robbery conviction. He got sentenced to 15 years for that. Level 3 was the recommendation.
Okay.
Your Honor,
Let's
brief
see.
fact-
Go ahead, Mr. Pierre. Yeah, you're not on camera, Mr. Pierre Thomas.
Oh, I thought it was. Thank you. Your Honor, brief
Okay.
facts of the case is that the defendant and the victim in this case being Miss Michelle spelled Michele, Lindsay, Lindsey, were involved in a child support case during which the defendant sent an email to her stating that he doesn't think don't think for 1 second that I don't keep that pistol on me, and I know you want revenge, but you're going to get hurt or killed. I'm going to run your ASS over. If it's war you want, don't tap when I get you in my clutches. That's a direct quote, Your Honor. The recommendation from the state in this case is $1,000 surety bond, no further contact with Miss Lindsay, the completion of an 8-week anger management course, and no drugs, alcohol, or weapons. And if at this time we can sound for Miss Lindsay in accordance with Marcy's law, that'd be greatly appreciated.
Ms. Lindsay, if you're present and wish to address the court, now is your opportunity to do so. Mr. Ty?
Yes, Your Honor. My client is a 45-year-old father of 2. The children are both adults. I believe one or both of them are shared with Miss Lindsay, the complaining witness. He states that the child support case came, after he was released from prison for 15 years, that she was going after him for $80,000 of child support. And I didn't see that email, but he stated that it stemmed from him telling her, stay in your lane or you'll get run over, which was not a threat, more like maybe a misunderstanding of saying stay in your lane, that he wasn't really threatening her in that way. But I did not see that email. He does have that open case from 2022 that he was dealing with when he found out about this warrant. He didn't know about it. He turned himself in. He understands his obligation to return to court. He's lived in Georgia his whole life. He is fine with no further contact with Michelle Lindsay, and we're asking for a signature bond through the jail.
And Your Honor, if I could be more specific, our office was able to get in contact with the victim in this case. The victim advised that she and the defendant shared the 2 children. She stated that she was seeking the child support and was in the middle of the child support case. She stated that they were on an email thread with the judge and the litigation manager when the victim and the defendant, when the defendant took the judge and the litigation manager off the thread and began to send the threats that I specifically quoted to the court. The victim stated that the defendant has been trying to reach out to her through their children. The victim also stated that she wants no contact with the defendant and does not want the defendant trying to reach out to her through the children. And so that's the I guess the indicia for our request of that surety bond, Your Honor, and the stay away and no contact, or the no contact, Your Honor.
All right. It will be a $3,000 signature bond through pretrial level 1-day anger awareness, no further contact with Ms. Lindsay, no drugs, alcohol, or weapons while out on bond. Mr. Jones, no contact means absolutely no contact, no phone contact, no physical contact, no email contact, no social media contact, no contact to third parties. There can be no contact whatsoever. If there's contact, then you'll be in violation of this bond order, okay?
That's on.
All right, good luck to you, sir.
Thank you very much.
Position 10.
Yes, good afternoon, Mr. Herforth. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 23 CR 007124G with criminal trespass. Is there a history, Mr. Howard?
33 total. 2023 probation. 2020 obstruction conviction. 2020 probation and obstruction conviction. That's a different arrest. 2019 obstruction conviction, trespass conviction. 2018 probation, obstruction, PI conviction. 2018 disorderly conduct conviction. Another 2018 PI conviction. 2018 failure to appear. 2017 trespass conviction, and a 2017 failure to appear. This was level 2.
Stand up.
Your Honor, this incident happened on the 16th of November. Officers responded to a criminal trespass at 630 10th Street Northwest. They spoke to a security guard there and Mr. Jamal Demons. Mr. Demons stated that the defendant was asked to leave the location multiple times and he refused. Officers then asked the defendant to leave the property several times and he refused, so he was arrested. The state is looking for a signature bond through pretrial and a stay away from 630 10th Street Northwest, and no drugs, alcohol, or weapons while on bond.
And 630 10th Street, do you know what that is?
No, but I can look it up 1 second.
Mr. Ty?
I'm not sure what the location is, but my client does state that he has an apartment. So he would be fine with the stay away from that location, and we're okay with the signature bond through trial.
It looks like it's a Quick Trip store, so it looks like I think it's a gas station.
Okay. It's going to be a $2,000 signature bond through the jail. Stay away from the Quick Trip on 10th Street. No drugs, alcohol, or weapons while out on bond. I'm gonna let you out, Mr. Herforth, but don't go back to that quick trip, or if they arrest you again, you'll be right back where you are, okay? Good luck, sir.
Position 15.
Yes, good afternoon, Mr. Mufanaga. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You've been charged in case 23 CR 007125H with battery family violence. Is there a history, Mr. Howard?
No. Jail was a recommendation.
Your
Mr.
Honor,
Pierre Thomas?
brief facts of the case, one moment. Brief facts of the case is that law enforcement responded to 6969 Roswell Road, Apartment A in Sandy Springs in reference to a domestic dispute. Upon arrival, the officer met with the caller, the victim in this case. Victim appears to be Lolo, Lolo, Plantain, Plantan, who stated that she and her spouse, the defendant, got into an argument over their son's discipline, or their son being disciplined. The verbal altercation turned physical when the defendant struck her in the face with a closed fist over and over again and continued to hit her on the left side of her face. She stated that she covered the right side of her face in order to protect herself and was attempting to push the defendant off of her. The victim sustained a visible cut on the inside of her lip on the left side, as well as discoloration marks on the left side of her face that appear to be in the beginning stages of bruising. The recommendation from the state is a $2,000 surety bond, no further contact with the victim in this case, Miss Plantain. Stay away from that incident location, 6969 Roswell Road, Sandy Springs. The completion of a family violence intervention program, no alcohol, drugs, or weapons. Our office was able to get in contact with the victim, and she advised that they live together and they share one child. She confirmed the events in the warrant. And she stated that this is not the first time that the defendant has been violent towards her, and this is not the first time that the police has been called out. She stated that this is the first time the defendant has been arrested, however. I do believe that she is on the call, and so we'd give an opportunity and sound for her in accordance with Marcy's law. So if we could sound for Ms. Plantain, that'd be greatly appreciated, Your Honor.
Yes, I see her there, Ms. Plantain. If you would like to address the court, I'll need for you to raise your right hand for me.
Yes.
Do you swear affirm the testimony? Okay, I can see you. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can put your hand down. What would you like to tell the court?
Your Honor, what I would like to tell you is what happened yesterday was a completely misunderstanding between me and Moses. Me and Moses, we have one child who is at the background here. I just picked him up from school. And this is our only child whom we love so much. So what happened yesterday was, a minor misunderstanding which escalated, and we as adults, we took full responsibility for not being able to behave ourselves. And then that's why, whatever happened had happened. But the bottom line is, Your Honor, Moses is a good father, a person of moral conduct. Of course, we do disagree at some point as parents, but the bottom line is a very good person. We normally disagree verbally, but nothing physical, and his son is here, is asking for him because today they plan going hiking at the Chattahoochee River. So he's a very good father. He's a very good person. I apologize for wasting your time for something which I am feeling so bad. It's something we should have handled, as a family. So this is very, very heartbreaking. We would like to have him back at home. We love him so much. His son has been asking a lot for him. He's back now and he's asking his mother's back home. And I'm like, no, we had to run into the car to take this call. So it's very, very emotional for all of us. So, Your Honor, I'd like to beg your mercy
for him so that he can be discharged. This is something which was not supposed to happen in the first place, but it happened. This is a very huge mistake, and we're going to learn from our mistake. And next time, as parents, we're going to handle ourselves, better, because what happened yesterday was not supposed to happen at all. So I beg your mercy, Johanna, please help us. I'm sorry, I'm very emotional. I'm so sorry, I'm very emotional.
I need for you to pull yourself together because I have some questions for you.
Yes, sir.
Okay. Did you find it necessary? And yeah, I am a bit that you have your child in the car while you're discussing these matters with the court. But that is your, no, I'm not telling you to let him out of the car, but what I'm saying, because I don't know how safe that is. But you've got a father that's in custody. You're emotional. Apparently, you had to call the police yesterday for this incident, and you're doing what you're doing right now, and that's in front of your son. That causes me distress. Okay, that should also cause you and Mr. Moses distress also. So, in answering my questions, has this ever happened before?
Yes, Your Honor. This has happened before in the past, where, like, we have some disagreements, and it's very, like, not something very serious, like very minor things. Maybe he doesn't disagree on something which I like to do for Gabriel, because as a mom, sometimes maybe I tend to spoil him a lot. So those kind of things which are very, very minor. Yes.
Okay,
but
well,
physical.
There are allegations of physical violence in this case. Has that ever happened before?
Yes, it has happened in the past, but not to the extent that happened yesterday.
Okay, and Mr. Pierre Thomas, do you have any questions?
I just want to be clear. Who called the police?
I did.
Okay. And why did you call the police?
So I called the police. I think, as I said earlier, I wasn't thinking straight. I was very emotional. I overreacted. I strongly believe it's something which we could have speak and talk about it, because, as I said, it wasn't something which was very major. It's about, how to discipline your child, how and when. So it's something, as a parents, as adults, something that we can do, and we can agree this is the best way to discipline our child.
Well, one thing. Did he lay his hands on you?
Yes. Sorry, can you repeat the question?
Did he lay his hands on you?
Yes, he did.
Okay, well, that does not have anything to do with the argument that you have over disciplining your child. Those are two separate issues. Okay? Him laying his hands on you, if that's what you're telling this court that he did, is not acceptable, regardless of what the circumstance. And you need to know that.
Yes, sir.
I'm concerned more about for that little boy that's behind you. You two are grown adults. But
yes,
the trauma that you're causing that little boy that's sitting behind you, you all need to think about that.
Yes, sir. So, sir, he's
behind me. I don't need sorry.
Okay.
Ms. Atai?
Yes, Your Honor. My client is a 39-year-old and does have the 7-year-old with the complaining witness. He has a master's in finance. He's not employed right now, states that he's depressed from his father passing, I think in 2019. The warrant does state that the disagreement or the incident stemmed from the complaining witness slapping the child, and my client did not agree with that. He does have an injury from the incident. He states that his tooth or the cap or something has fallen out from his mouth, and he needs a dental visit, I guess, as Ms. Planton has requested to have him return to the home. We're asking and there's no criminal history or violent history. We're asking for a signature bond and no stay away.
Okay, as this just happened yesterday and what I've heard today and my concern for that child, there will be a stay away. I'm going to, given that he doesn't have a history, it will be a $3,000 signature bond through pretrial level 1 with 1-day anger awareness. As far as contact, there is to be no further contact at this point in time with Ms. Planton. He is to stay away from the Roswell Road address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. I'm not going to keep him away from his child, but there will be third-party contact with the child for visitation, and no drugs, alcohol, or weapons while out on bond. So no contact means absolutely no contact while this is being resolved. Mr. Moses and Ms. Lola, you all both need to think about the consequences that your child is suffering because of the two of you grown adults.
Yes,
All right.
sir.
Good luck to you all.
Thank you.
Okay, next we have position number 6.
Good afternoon, Mr. Goodrum. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Afternoon, Your Honor, and yes, I do.
Yes, thank you, Mr. Goodrum. You've been charged in case 23 CR 007117J with battery family violence. Is there a history, Mr. Howard?
His last arrest was in 1986. Jail was a recommendation.
Okay, thank you. Ms. Dunlap?
Thank you, Your Honor. This incident stems from yesterday. The victim is the defendant's sister, Jennifer Haggins. Stated the defendant balled up his fist and struck her in the face and ear. She sustained a swollen ear and several abrasions to her face. This happened at 128 Holly Road Northwest in Atlanta. The state is looking for a signature bond through pretrial, a stay away from 128 Holly Road Northwest, no further contact with the victim, Jennifer Haggins, 1-day anger awareness, no weapons, drugs, or alcohol while on bond. The victim advocate did speak to the victim. She stated that this is the first time this has happened, but he did attack her after they got into an argument and struck her in the face 6 to 8 times. She did state to the victim advocate she's not in fear of defendant and okay with having contact with him and him visiting the residence. That is all, Your Honor.
Ms. Abden?
Your Honor, my client is 58 years old. He was born in Georgia. He moved away for some time, and he came back 3 years ago to care for his sick mother. The incident location is his mother's address, and it's my understanding that his sister was residing there, but she's since left to stay with her daughter due to the incident. My client firmly denies the allegations without going too much into the facts. He stated that she was the first aggressor and he was defending himself. However, he also confirmed that there's never been prior instances of violence, and he would prefer to have no further violent contact. He is the primary caretaker for his mother. He takes her to all the doctor's appointments. He goes to 3 to 5 appointments with her per week. He's also gainfully employed at UPS. He's been working there for 15 years. He's been happily married for the past 29 years. He's a father to 3 adult children and a grandfather to 12 grandchildren. He tells me he's very involved in his grandchildren's lives. His 9-year-old grandson has a game tomorrow, and he's helping with the team, so he's hoping to be back for that. So we would object to the stay away. As I've stated, he does need to go back there to care for his mother, and we would request a no further violent contact. If Your Honor is inclined to grant that, given the complaining witness's request. And as the recommendation is a signature bond through the jail, he has, his last arrest was in 1986. I am requesting a signature bond through the jail.
Your Honor, if we may, we recommended a signature bond through pretrial. The victim advocate, she did tell her that she does still live at that address today. And we do understand that she wants contact, but this incident also happened less than 24 hours ago, and she had visible injuries.
Well, a cooling off period is not statutorily required. He doesn't live there. He would just need to go back there to care for his sick mother. And he told me that his mother told him that the complaining witness is living with her daughter. But if no further contact is required, despite the fact that she's requesting no further violent contact, then he would be able to abide by that.
Okay, it will be a $2,000 signature bond through pretrial level 1 day anger awareness, no further violent contact with Ms. Hagens, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Goodwin.
Thank you, Your Honor.
You're welcome, sir.
Position 1, Alston.
Good afternoon, Mr. Austin. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good afternoon.
Good afternoon. Mr. Austin, you've been charged in case 23 CR 007110F with theft by deception. Is there a history, Mr. Howard?
No. Jail was a recommendation.
Okay. Ms. Dunlap?
Thank you, Your Honor. This incident happened on the 14th of March at 1 Sandy Creek Road Northwest. Officer responded to a call regarding a larceny at a training orientation. The victim is a Mr. Charles Milton. He said he let the defendant use his personal cell phone to complete a survey after the new hire orientation. When he checked his Cash App the next day, he saw a $200 Cash App to an unknown person. He said the alert matched the time the defendant was in possession of his phone. And Mr. Milton did ask the defendant about the Cash App transaction. Defendant admitted to sending the Cash App to himself because he stated times are hard. The state is looking for a signature bond through pretrial. I believe stay away from 1 Sandy Creek Road Northwest. I believe that was a training orientation. Unaware if he actually still works there at this point. No further contact with Charles Milton. Oh, he does not work there. An anti-theft course and no weapons, drugs, or alcohol while on bond.
Ms. Abden?
My client is 28 years old. He does firmly deny the allegations. This was a UPS he was working at, and he stated that the complaining witness he's denying the allegations. I'll just leave it at that for now. And he moved to Georgia from South Carolina about 6 years ago to be closer to family. He lives with his grandma here in Georgia. His mom also lives here, other family members as well. So he does have strong ties to the community. He is gainfully employed at Home Depot. He works in the lumber department and is in the works of becoming the assistant manager there. He only works part-time and will likely not be able to return to work since he's been in jail he tells me he's been in jail for over a week waiting to get transported from Clayton County. I wasn't able to confirm that, but it may be a Riverside issue. I'm not sure. And he's also receiving SSI, Your Honor. So he does have limited income. His indigency is a concern. And I've also connected him with a social worker to assist him with MH. He's a father to 3 minor children, 2 of which are 5 and 3. They reside with their mother, and he has a newborn at home. He is the primary caretaker for that baby. The mother works full time, so he's the only person who really cares for that child during the day. He also has a sister here in Georgia who has MH, and he goes to take care of her twice a week. And so, Your Honor, given all that, and the fact that he does not have a criminal history, the fact this happened a really long time ago, he would not object to a no further contact and a stay away if that's required. I am requesting a signature bond through the jail.
Okay, it'll be a $2,000 signature bond through the jail. No further contact with Mr. Milton. Stay away from the Sandy Creek Road address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Austin.
Thank you.
You're welcome.
Position 7, Goodson.
They wanted a breakout room for position 7. Is this the
Yeah.
last position?
No, we got a few more. We can move on to the next. Position 8, Harris.
Okay. Yes, good afternoon, Mr. Harris. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Yes.
Thank you. Mr. Harris, you've been charged in case 23 CR 007120D with loitering and prowling and theft by taking. Is there a history, Mr. Howard?
17 total. Last arrest was back in May. DeKalb County, entering auto and burglary. That's open. 2018 probation. 2017 theft by receiving obstruction conviction. Got another 2017 probation. 2014 simple battery no-low obstruction conviction. 2013 probation. That's all.
Ms. Dunlap?
Incident happened yesterday on the 16th of November. Location 6161 Ferry Drive, Sandy Springs. It looks like there were 2 defendants involved. Officers were called to report of a theft at this residence. They met with the victim, Robert Murphy. He was performing lawn services at 6161 Ferry Drive when someone came and stole his leaf blower. The homeowner had a camera and they watched the SUV that the defendant, looks like he was coming out of, wearing a blue hoodie, black pants, took the leaf blower. Once officers were able to locate the car, the defendant and 2 other individuals were inside. The blue hoodie was on the ground in the back seat when officers pulled the car over. Looks like the co-defendant was the driver and the defendant here was a passenger. The leaf blower was in plain sight. The co-defendant stated that he was driving the SUV all day, couldn't specify where he was at, then changed his story and said defendant here was driving before they were stopped. The co-defendant stated that the defendant here paid him to pick up his girlfriend, who was the 3rd person in the car at the time. They could not advise how the stolen leaf blower got into the SUV. They're not the owners of this vehicle. The owner stated that none of the items in the SUV are hers that were stolen. And officers determined that the defendant had on a similar outfit to the homeowner's camera that stole the leaf blower while the co-defendant was acting as the getaway driver. It looks like this is set at a $5,000 surety bond. The state is asking for a signature bond through pretrial services, a stay away from 6161 Ferry Drive, no further contact with the victim, Robert Murphy, anti-theft course, no weapons, drugs, or alcohol while on bond.
Just
And
so I
this was a
understand.
dual. Sorry, Your Honor. This was a dual position 5, and he has bonded out.
Okay, so they were in an SUV that was allegedly stolen.
No, the SUV is owned by one of their mothers, and they pulled up to someone's house and stole a leaf blower and then pulled off.
Okay, so the SUV was not, okay, I understand. Yes, Miss Abden.
So my client is 31. He's been living here consistently in Georgia for the past around 11 years. He lives here with his mom and other family here as well. So he does have strong ties to the community. As he resides here in Georgia, understands his obligation to return to court. And there are no failures to appear from the past 5 years. He's not a flight risk at this time. He's also gainfully employed. He works in construction. He's been working there for about a year and 2 months. My client firmly denies the allegations as stated in the warrant. My client recently lost his son to a house fire, Your Honor. That was about 7 months ago. His son was only 8 years old. He has another minor child who resides with him. That child is 6 years old. He does have familial obligation to that child. And given this tragic loss of his son and the home, his indigency is a concern, and he would not be able to afford a bond today. And I think that reporting to pretrial would be difficult for him as well. But if Your Honor is inclined to grant him a signature bond through pretrial services, he'd make it work. But I am requesting a signature bond through the jail.
Your Honor, I actually misspoke. It was position 5 that bonded out, not position 6.
Okay, thank you, Ms. Dunlap. Let's see, will be for each count a $2,000 signature bond through pretrial, makes it a total of a $4,000 signature bond through pretrial. Level 1, Stay away from the Ferry Drive address. No further contact with Robert Murphy, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Harris.
Thank you, thank you.
Position 9, Haywood.
Yes, good afternoon, Mr. Haywood. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Let's see, Mr. Haywood, you've been charged in case 23 CR 007123C with loitering and prowling and willful obstruction of law enforcement officers. Is there a history, Mr. Howard?
Second arrest. 2022 sale of marijuana and distribution of it. This was a jail recommendation.
Ms. Dunlap?
Thank you, Your Honor. This incident happened on the 14th of November at 1178 Piedmont Ave. Officers were dispatched to 1178 Piedmont Ave on reports of a prowler. Officers tried to make entry through the back door because the front door was locked. They observed the defendant leaving from the back of the building. As they tried to approach the defendant, he took off running to the pool area. He was given multiple commands to stop and he disregarded. He ended up jumping over the fence of the pool area and tried to hide under the pool house. He then decided to jump in the lake but couldn't swim. Officers threw the defendant a life buoy and transported him to Grady. The victim in this case is a Kalia Davis. She stated that someone was knocking at her door. She lives alone and she wasn't expecting anyone. The state is looking for a signature bond through pretrial, a stay away from 117 Piedmont Ave, no further contact with the victim, Kalia Harris, and no weapons, drugs, or alcohol while on bond.
Ms. Abden, if it's okay with you, it's going to be a $2,000 signature bond through the jail on each count, which makes it a total of a $2,000 signature bond through the jail. No further contact with Ms. Kalia Davis. Stay away from the Piedmont Avenue address, and no drugs, alcohol, or weapons while out on bond. Does that suit you?
No objection. Thank you, Your Honor.
Okay. I think if you're gonna allegedly jump into a pond, you need to learn how to swim, possibly, Mr. Haywood. So good luck to you, sir.
Thank you. I do know how to swim, and I used to live at that address. I was not crawling.
Okay. All right.
Mr. Haywood, I would advise you to exercise your right to remain silent at this time.
Okay.
Thank you.
Judge, for the breakout was for position 7. Was that?
Yes.
Okay, we have one more, position 2, Mr. Bethea. How does he?
Good afternoon, Mr. Bethea. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You have been charged in case 23 CR 007111F with terroristic threats and acts. Is there a history, Mr. Howard?
39 total. Last arrest was in October. Probation. He got open cases for theft by deception out of the cab in 20. False report of a crime, simple battery, family violence. Theft by taking, trespass, suspended license, giving false name, criminal damage to property, first degree. Egg stalking, endangering a child by DUI, on probation in Cobb. 2023 failure to appear. 2021 probation. 2020 failure to appear. 2019 FTA and an arson arrest. Another 2019 failure to appear. That's it.
Ms. Dunlap?
Thank you, Your Honor. This incident stems, looks like, from August 30th, 2022. Officers responded to a call regarding obscene text messages. They met with the victims, Dana Clancy and a Janelle Adams. They stated they had to give the defendant a truck to move, and the defendant was supposed to return it. He never returned the truck. Ms. Clancy reported the truck stolen. Ms. Adams, who looks like was his roommate or is his roommate, was tracking his location. They located the truck at a Cortlandt Street, / John Portman Boulevard. While they were waiting for officers to arrive, the defendant began sending them obscene text messages of insulting them. He sent a message stating that he would kill them and sent a picture of him next to their truck. The state is looking for a $1,500 surety bond. A stay away from the victim is Dana Clancy's home address. No further contact with Dana Clancy. If Miss Jonelle Adams is no longer his roommate, no further contact with Jonelle Adams. 1 day anger awareness, no weapons, drugs, or alcohol while on bond.
Ms. Abden?
Your Honor, this incident allegedly occurred August of 2022, I apologize. So he no longer resides at this location, and he does not have any contact with the complaining witness. He does deny the allegations as stated in the warrant. I do understand he does have a criminal history. He has a lot going on currently in terms of warrants. He has 2 FTAs, it appears, and also a foreign county hold. So even if he does get a signature bond today, he will not be able to be released. He is 41 years old. He's been living here in Georgia for the past 32 years. He has family here in Georgia, including his mom, so he does have strong ties to the community. He's residing here in Georgia with his girlfriend, who is pregnant, and she does need him home to help care for her and help her financially as well. He tells me that she is due soon. He has been in custody for the past 38 days for an unrelated matter, and he got transferred here for this old 2022 warrant. So as a result, he's not been able to work. His indigency is a concern, and he would not be able to pay any bond. I understand the bond is currently set at $3,500. And so even if it was reduced, he could not pay it. He was gainfully employed. He had a TV installation company. He's been doing that since 2015. And then he also had a second job at a diner. He was the kitchen manager, but as he's been in custody for 38 days, he doesn't think he can return to that job. Obviously has not had any income from his other job. And so given all that, Your Honor, I am requesting a signature bond through the jail so he can go handle his other matters.
Okay, I'm gonna release him to the hold. It'll be a $3,000 signature bond through the jail. No further contact with Miss Clancy and Miss Adams, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Bethea.
Come on,
Okay, so I think the last one.
Position 7.
Okay, so we'll go into a breakout for that position. Before I go into the breakout, Mr. Howard, is there a history?
48 total. 2022 failure to appear. 2022 shoplifting conviction. 2020-2018 parole violations. 2018 shoplifting conviction. 2015 probation, failure to appear. 2014 probation. 2012 shoplifting conviction. I think it's level 3.
Okay, so let's see. Ms. Falk, Ms. Dunlap, Ms. Abden, myself, anyone else need to go into the breakout room?
I would like to go, Your Honor.
Okay. Ms. Kim, Mr. P.R. Thomas. So Ms. Champion, if you'll put us into the breakout room, thank you. Yes, good afternoon, Mr. Goodson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video.
Yes, sir.
Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Goodson, you've been charged in case 23 CR 0071188A with theft by shoplifting and willful obstruction of a law enforcement officer. I've had an opportunity to discuss your case with your counsel and with the solicitors, and your bond will be a $2,000 signature bond through the jail. It's $1,000 per charge, so $2,000 signature bond through the jail. You can't go back to that Dillard's at North Point Circle. No drugs, alcohol, or weapons while you're out on bond. And I want you to abide by any present treatment plans that you have, okay? All right. Good luck to you, Mr. Goodson.
Thank you, sir.
You're welcome, sir. Good luck.
I have a couple of announcements, Judge.
Okay.
For position number 3, bond has been paid.
Okay.
Also, position 4, bond has been paid.
I already did them. It's 3, 4, 5, and 18.
Oh,
Just to
also
save you some
5,
time.
So what?
Just to save you some time.
So you say position 5 also bond is paid?
Yeah, I put it in the chat when I got on.
Okay.
3, 4, 5, and 18.
Come on.
Okay. All right. Thank you, Francois. Thank you also, Mr. Howard. Okay. All right. Ms. Strong, whenever you're ready.
Position number 1 was a $2,000 signature bond through the jail. Position number 2 was a $3,000 signature bond through the jail. Position number 3 was released. 4 was released. 5 was released. Position number 6 was a $2,000 signature bond through pretrial level 1. Position number 7 was a $2,000 signature bond through the jail. Position number 8, $4,000 signature bond through pretrial level 1. Position number 9 was a $2,000 signature bond through the jail. 10, $2,000 signature bond through the jail. Position number 11 was a $3,000 signature bond through the jail. Position number 12 was null pros. Position number 13 was a $3,000 signature bond through pretrial level 1. Position number 14, $2,000 signature bond through the jail. Position number 15, a $3,000 signature bond through pretrial level 1. Position number 16 was a $2,000 signature bond through the jail. 17 was a $2,000 signature bond through a pretrial level 1. Position number 18 was released. Position number 9 was a $3,000 signature bond through a pretrial level 1. And position number 20 was a $3,000 signature bond through the jail.
Questions, comments, concerns?
Nope.
All right. Y'all have a good, nice weekend. Be safe.
You too.
See you next time.
You too. Thank you.
Thank you.